Welcome back to the Liberty Block. I'm Alu Axelman, back with another hopefully short video and podcast on my series on Supreme Court decisions. This one is a way older one. It is a canonical case, very famous, pro-defendant case, or is it really pro-defendant? We'll get to that, called Brady versus Maryland from 1963. I've been mostly focused the last few months or years on cases that the Supreme Court decided and published at the time, so like 2024, 2025, and I do want to do some videos explaining the cases that interest me that they're coming out with now that the 2025 session is coming to an end, or it's over now that it's summer. But this case, I've just learned recently, the last few days to be honest, while working on some other projects for other books and stuff, that Brady versus Maryland was not as pro-defendant as people think it is. In fact, I would argue it's not pro-defendant. It's like pro-state. And it has some interesting, intricate wrinkles that I just find to be fascinating from just an academic and legal arguments standpoint. So, Brady versus Maryland is known, almost as famously as Miranda v. Arizona and stuff like that, as the case that decided that the United States Constitution, Fifth Amendment due process clause, I believe, gives defendants the right to have generally the evidence that the prosecution plans to bring at trial. In this case, it was exculpatory evidence that the prosecution was in possession of, the prosecutor and or police were in possession of, that they failed to give to the defendant, and therefore they violated his due process. As I often ask, but what's the remedy and what's the consequence? And we'll get to that. So, let's get into the facts of the case, and then I have a few quick points on it. It was decided 7-2 by the Supreme Court, with only Justices Black and Harlan dissenting. And John Brady was trying to apparently obtain some money. I heard one person say, a law professor, I think, that he was trying to get a $35,000 check for his girlfriend or something, and then he signed it and gave it to her and realized it would bounce because he did not have that kind of money in his bank. In 1963, $35,000 was, I don't know, probably the equivalent of like $400,000 today. So it's a lot of money. He wanted to rob a bank, but before he could rob a bank, he needed a fast car. So he figured him and his friend Boblet would rob this guy's car. They knew someone who had a fast car, so they figured a brilliant plan they had was take a big tree branch, and throw it on the road so that when Boblet's driving down that road on the way home from work or something, he'll have to get out of his car and remove the tree, and while he's doing that, they're going to steal his car and or knock him out and kidnap him and just take his car. So, apparently, from what the case record says, they did this and it actually worked out decently. They knocked him out, threw him in the backseat of the car, I believe. So it's already armed robbery, grand theft auto, kidnap. So much of violent crimes that Boblet and Brady committed. So remember, there's these two people who are committing this crime. They didn't plan to kill him, I don't think. They just wanted to rob his car temporarily, just for a quick bank robbery. And then they were going to drive to some woods and throw him out into the woods so he could not disrupt their plan to rob the bank. And what happened, and what was revealed later, but what happened according to all of the parties who admitted to it, Boblet got out of the car and threw him in the woods, and then used a shirt to strangle this man to death. So they killed him. So that would seem to be murder, likely first-degree murder. It was pretty premeditated. It was on purpose. So Boblet murdered this guy. I forgot his name. I'm not sure if it's in the documents. Now, Brady was involved. Brady was not a good dude. Probably wouldn't want to be friends with him. But he certainly did not commit murder. He committed armed robbery, maybe accessory to murder, maybe kidnap, theft, all sorts of stuff. but maybe conspiracy to commit murder, maybe if you believe in those kinds of charges. But he didn't. Now, they were both arrested because they were caught. They were charged in Maryland court with first-degree murder. And at that time, it was not necessarily clear from the charges which of them did the murder, but because Maryland, like pretty much all states, have a felony murder rule, and I write about this in Presumed Guilty, which is back there, my book, for those who can't see. I have a whole chapter on how much I love felony murder. And by love, I mean I hate, because it's one of the craziest doctrines. It's essentially a doctrine that like 46 states have that says if you're involved in any felony, if you're involved in it at all, even if you're not a bad person, like if you lend someone a car because they're a nice guy, if they then commit a felony, and if anybody dies in connection with that felony at all, you can be charged not only with a felony, but for first-degree murder, by way of the felony attaching to the murder and attaching to you, and they call it felony murder. It's a doctrine or a rule that states have, and their statutes that allow prosecutors to bring charges. So regardless of whether one person or the other both killed someone, they both were going to be charged with first-degree murder by way of felony murder, because they were both involved in the felony, and that part's not disputed. They were both involved in the felonies of armed robbery, kidnap, and so on. So anyway, I believe Brady was charged first, or had the trial first, and his lawyer asked the prosecutors for all of the statements made by Brady and by Boblet, because they both had made statements to police. I guess they were with their lawyers or weren't smart enough to not talk to cops without lawyers present, but they spoke to police, they gave some statements. One of Boblet's statements straight up said, I was the one who took the shirt and strangled the guy to death. I killed him. So Boblet confessed to the murder. That part's very simple. A toddler could understand. Boblet confessed to the murder. So I'm going to keep repeating that. Brady did not. He denied the murder. He admitted to what he did, but at trial, when he was on the stand, he denied the murder. He said Boblet killed him. But the prosecutors never turned over that statement. They gave him other statements that were not good for Brady, but the prosecutors willfully suppressed. They did not give, even after a request, the confession to the murder by Boblet to Brady, which is a very big issue. They were both convicted. So Brady, I believe, convicted first of first-degree murder, and in Maryland at the time, when convicted of first-degree murder, they have the death penalty. So the two punishments could be life in prison or the death penalty if someone's convicted of first-degree murder. And they're, I believe, essentially separate kinds of proceedings, which my understanding is they still are now. The jury has to decide on the conviction, and then after that they decide whether to execute the person with the death penalty. So in this case, they returned with the verdict of first-degree murder with capital punishment. So they were going to kill Brady, and I believe Boblet was also convicted of first-degree murder with the capital punishment. So they both were set to be executed by the state. Now, after this conviction, and he was sentenced to be killed by the state for murder, although he didn't actually kill anyone, and at the most it was an accessory to murder, which would not be an execution for him. The Brady appealed. I don't know if there was only one appellate court in the state, but it says here the Maryland Court of Appeals, which was seemingly the court of last resort in Maryland, and they held that the suppression of the evidence by the prosecutor did deny Brady due process, so they said, you are violated, the prosecutor didn't give you the info that was very much exonerating, exculpatory evidence, because your partner in crime admitted to the murder. But the Maryland Court of Appeals, and this is where it gets tricky that nobody knows, or I didn't know until a few days ago, the Maryland Court of Appeals said nothing in the suppressed confession could have reduced Brady's offense below murder in the first degree. And therefore, it remanded the case for a new trial, but only on the question of punishment, not on the question of guilt. So, to explain another way, the Maryland Court of Appeals said, yes, you were wronged, they violated your right to due process, and you're still convicted of first-degree murder. We're not going to have a new trial for that. That is set in stone. You committed first-degree murder because felony murder would mean since they were involved in the underlying felony kind of conduct, and since a person did die, you would have been convicted by any jury, 100% unanimous conviction, all 12 of them, even had they heard Boblett's confession, if that were in evidence, and Boblett admitted to the singular killing, still, because of felony murder, and the judge would have instructed them in the jury instructions that felony murder, is a thing and how it works, that the Maryland Court of Appeals was positive, so positive, like 100%, not even like beyond reasonable doubt, whatever. They seem to say they're 100% positive that even if the confession by Boblett was used in the trial, was given to the defendant, and he used it and the jury heard it, they still would have convicted of first degree. But the only tiny concession they gave was maybe they would have returned with a verdict of murder in the first degree without capital punishment. Maybe. And they gave a new trial just so that the jury can determine whether he should be executed for his first degree murder or held life in prison for his first degree murder. Brady, as you might imagine, was not very happy about that because that's barely a win. I mean, he probably didn't want to be killed, but that's not a win. I would call that like a 20% win, and not really a 100% win, because the case was not even set for retrial. It was not dismissed. The prosecutors were seemingly not punished for the horrible, egregious violation of his due process, and they should have known a lot better. Anyway, from the Maryland Court of Appeals, Brady appealed to the U.S. Supreme Court, and the U.S. Supreme Court, pretty much fairly simple, they just agreed with the Maryland Court of Appeals, and they said, yes, that's exactly right. His due process was violated. The prosecutors have a responsibility under the federal and state constitutions to give over all evidence favorable to the accused, especially if he requests it. But he's going to get a new trial only for punishment because they agreed with the Maryland Court of Appeals that it wasn't that big of a deal, the evidence. Again, and this is, I don't want to say it's an as-applied challenge versus facial, because I don't think that's really the concept that applies here, but they were just saying in this case, they weren't categorically saying that, obviously they weren't saying in any case where there's a Brady violation, where prosecutors suppress or fail to give over exculpatory evidence, that in all those cases, the conviction remains, but the punishment could be determined once again. They could have a new trial to determine punishment. That was just this case. They held that it wasn't that important, the confession, which I would think if one person is dead, there was only one murder that existed, and someone else confesses to it, I would think that makes a big difference on the bearing of your first-degree charges. But what do I know? I'm not even a lawyer. I'm not even in law school. I'm just some random dum-dum on the internet. So that is the case. Before the case, there was a bit of history in Napieu versus Illinois, which is referenced by some people regarding exculpatory evidence. The Supreme Court held, so this is 1959, 4 years before Brady. The Supreme Court held that the failure of the prosecutor to correct the testimony of a witness, which they knew to be false, did deny due process to the defendant, was a violation of the 14th Amendment. So that was just for testimony. If the prosecutors put up one of the witnesses on the stand and they knew he was lying and they essentially aided and abetted perjury, that's a violation of due process. After Brady, a few years later, in Giglio versus United States, the prosecution failed to tell the defendant and the jury that their star witness was testifying in exchange for leniency. So it was a proffer deal or something where they gave this guy some leniency for his sentence, and that obviously makes him less credible, I would say, and the jury might think that if the government is giving him something in exchange for him saying certain things on the stand, that could make him a little less reliable. So the Supreme Court held that was material, that was something that mattered, and it violated the due process rights. Interestingly, in Brady, my understanding is the Supreme Court held that even if it's not made in bad faith, whether it's a mistake or it's made maliciously, in Brady the prosecutors seemingly were malicious, but I believe one of their holdings was that even if it was a mistake, an oversight by the prosecution, and they didn't mean to suppress evidence or fail to give over certain exculpatory evidence, still it's a violation of Brady. It would be a worse violation if it's done on purpose. And there were some cases later on where that happened, I believe, but whether a mistake or not, as long as it's material to the case, something that's important, and even regardless of whether they ask for it. That, I believe, was added in a further case, in a later case. But I'll get to those cases. So, in Giglio, the Supreme Court held that it was material, and it was a violation of due process for the prosecution failing to tell the defendant their star witness was testifying in exchange for leniency. Years later, in U.S. versus Bagley in 1985, their star witness was a paid informant, so very similar. He was maybe not working for the government, but they were paying him. He was a government asset. The defendant was convicted of a narcotics offense. He was acquitted on a firearm charge. Maybe he had a gun legally, or without the right licenses. The Supreme Court held that this information was not material because there was not a reasonable probability that the outcome would have been different, because the informant was technically only paid for the testimony on the firearm charge, and he was acquitted of that charge. It was the narcotics offense that he was convicted of. So the Supreme Court did not agree with the defendant in that case. In 1995, in Kiles versus Whitley, the Supreme Court held that the failure to disclose evidence violated the defendant's due process, and it clarified 4 aspects of the test. So again, a 4-factor test like the Supreme Court often does to determine whether there's been a violation of the Brady doctrine. 1 is reasonable probability, whether the government's failure to disclose information undermines confidence in the outcome of the trial. 2, reasonable probability is not a sufficient evidence test, and the defendant does not need to show that the evidence, barring any evidence undermined by the withheld information, is inadequate to support a conviction. Rather, the defendant merely must show that the withheld information can reasonably be taken to put the whole case in a different light. 3, failure to disclose information which has reasonable probability of changing the outcome of the trial is inherently harmful. There's no need for a separate harmless error review. So if it had a reasonable chance of affecting the outcome of the trial, then that's considered inherently harmful if they withhold that. So that's good. And 4, all information that's not disclosed, so all suppressed information, must be considered collectively, not item by item. So if they fail to give over 14 different pieces of evidence that tend to be exculpatory, they should be taken as a whole. And if as a whole they would change the light of the way the trial looks, that could be considered a Brady violation. So not one by one. Now, let me just get to my main takeaway points, and then I believe we'll be done. I think this is one of those cases where, in my opinion, bad facts make bad law, I think is a famous saying with these constitutional cases, because few people would argue that Brady was a saint. It reminds me of a case from a year or 2 ago of Rahimi, where he was most likely a bad dude, probably. Like a woman beater, shot people pretty often, committed a lot of crimes. And in this case, John Brady, undisputedly was forging checks and armed kidnap and robbery and accessory to murder. So I think that does affect the judges, even the highest judges in the land. I think just their impression of him as not being a saint might have affected a little bit their decision to not grant him the relief he sought, really. So the Court of Appeals and the Supreme Court said the confession would not have reduced first-degree murder. It would not have reduced it any less to the second degree or something. That, I just wrote WTF for what the friggin' is going on here. We discussed that, and we discussed felony murder. And those were all the things that I wanted to address. Maybe I'll do a whole podcast on felony murder if it's requested. So, I believe those are all the cases. I do want to confirm one thing that I didn't really get to. I believe after Brady, I'm sorry, I'll have to confirm whether it was that case or a subsequent case, but the prosecution has to turn over evidence that's exculpatory or inculpatory. They have to turn over all evidence. That was either from Brady or from one of the cases, Giglio or Bagley, but that is the law now. All prosecutors in the United States have to give over all the evidence, good and bad and everything else. They also have to give over all the evidence if it's not only owned by them, but also by any state agency, so police or DCYF or something else, or IRS, but whatever agency. If they have any information that could be exculpatory, they do have to find it. They have an affirmative duty to find it and give it to the defense before the discovery deadline. So maybe a month or whatever, a week before trial, depending on the exact state's procedure rules. Also, as I touched on, the defense does not even have to ask for it. It's not like pleading, saying you need a lawyer, the Miranda rights or the right to remain silent or whatever. You don't need to ask for it. There's just a duty for all prosecutors to give over all the evidence to the defense, and it's an ongoing duty. So if they discover more evidence that could be material to the case, they do have to, as soon as they discover it, they have to give it over to the trial. Now, to the defendant. Now, the other issue is remedy. That's where it gets tough. Generally, the remedy for something like this is like a retrial. Those are tricky. It takes a lot more time. There's a speedy trial issue because it'll take them years and years, and they've already suffered. And there's the jury. If it's a jury trial, they can be tainted by if it's a high-profile case. One of the cases I referenced is like apparently Ted Stevens, who was a U.S. senator. So in that case, in D.C., like the jury, very likely the jurors will know. They'll be very familiar with the case. And that one I believe was dismissed. But if it's set for retrial, so that could be a few issues. In only a few cases, I only found a few, where it was dismissed, the charges, after an egregious Brady violation. In some cases, the prosecutors could be held in contempt if it's really, really bad, but that takes a lot. It's really rare. I came across one the other day, but I don't know how common it is. And dismissal is not common. I think the most common thing is a retrial, but the reason I made this video is Brady was so weird because they kind of threaded the needle. It wasn't a total retrial, it was a retrial only partially, only for the punishment, not for the actual conviction of guilt. So I wanted to just explain that. Hopefully I explained it decently, clearly for everyone. So that's what I got. Hopefully I didn't make too many mistakes in the video. I'm going to go over a few related cases, but I just thought it was really cool that it's seemingly known as a very much pro-defendant case, but Brady probably felt like it was not that pro-defendant. And for those worried about Brady, he did get a new trial just for the sentence, and the jury came back with first-degree murder. He was convicted already, but they determined it'll be without capital punishment, so he would not be killed. Yay! He was sent to life in prison. I heard he was paroled after 12 years or 18 years or something, and then he moved south and married a nurse and lived out his days, hopefully without too much more armed robbery and kidnap. So Brady did okay. Boblet, I guess he was killed. So he's listening to this podcast from hell now. So, all right, I think that wraps things up. We're still below 30 minutes, which is great. And I believe that's all I got. Check out libertyblock.com for more. Stay tuned. These podcasts will be coming around. Hopefully a few more on similar issues. I'm excited about some of the cases the Supreme Court just decided this term, 2025. And check me out at Alu Axelman on X and all the socials, at LibertyBlock, libertyblock.com, aluaxelman.com. And, check out the brand new book. I just gave away my last copy to a neighbor, but it's called Delayed and Denied. And it's about speedy trial, super short booklet. I made it as cheap, literally as cheap as Kindle. Amazon would let me for Kindle and for paperback, and I'm working on the audiobook now. So stay tuned. Thank you very much, and have a great day.